Washington. The Trump administration's losing streak in courts around the nation has in large part been a product of precedents established by conservative judges in the Obama era. It turns out, legal principles meant to curb executive overreach are indifferent to the president's party. Republican officials had great success under President Barack Obama in persuading judges to block or complicate his efforts to expand health care, shield immigrants from deportation, and protect transgender students. Now Democratic officials are using the principles established in those cases to frustrate President Trump's efforts to limit travel from predominantly Muslim countries and to punish so-called sanctuary cities. Both sides have shown remarkable dexterity in their understanding of the law, abruptly switching positions on issues like whether states have standing to sue, whether individual federal judges may issue nationwide injunctions, and whether a federal threat to withhold funds can amount to a constitutional violation. Josh Blackman, a law professor at South Texas College of Law, said Democratic officials should strive for more consistency, even if only as a matter of self-interest. Whatever California can do to resist immigration law, Professor Blackman said, Texas can do to resist environmental laws. Ilya Samin, a law professor at George Mason University, made a similar point from the opposite direction about Tuesday's decision blocking efforts to withhold federal money from sanctuary cities. Some conservative Republicans may not like the outcome of this specific case, he wrote on the Volokh Conspiracy, a legal blog, but they will have reason to celebrate it the next time a liberal Democratic president tries a similar move. In Tuesday's decision, Judge William H. Orrick of Federal District Court in San Francisco relied on a 2012 Supreme Court decision allowing states to opt out of the Affordable Care Act's expansion of Medicaid. That ruling, which added major complications to the rollout of the health care law, was popular with conservatives. The decision, National Federation of Independent Business v. Sebelius, was best known for sustaining a central provision of the law, its individual mandate. But the court also ruled, Congress may not impose significant new conditions on existing federal funding, a position pressed by states led by Republicans. When the case was argued, Justice Antonin Scalia, who died last year, highlighted the political realities of the opposition to the Medicaid expansion. Is there any chance that all 26 states opposing it have Republican governors, and all of the states supporting it have Democratic governors? He asked. There's a correlation, Justice Scalia, said Paul D. Clement, a lawyer for the states challenging the law, to laughter. In Tuesday's ruling, in a case brought by two California counties, Judge Orrick said the principle established in 2012 applied to the Trump administration's threat to withhold federal money from localities, refused to aid efforts to deport undocumented immigrants. The Supreme Court concluded that the Affordable Care Act's threat of denying Medicaid funds, which constituted over 10% of the state's overall budget, was unconstitutionally coercive and represented a gun to the head, Judge Orrick wrote. The executive order threatens to deny sanctuary jurisdictions all federal grants, hundreds of millions of dollars on which the counties rely. The threat is unconstitutionally coercive. Mr. Trump pledged to appeal Judge Orrick's decision to the Supreme Court, which this month regained a conservative majority with his appointment of Justice Neil M. Gorsuch. First, the Ninth Circuit rules against the ban, and now it hits again on sanctuary cities. Both ridiculous rulings. Mr. Trump wrote on Twitter. See you in the Supreme Court. The United States Court of Appeals for the Ninth Circuit in San Francisco has not ruled in the sanctuary cities case, though it did affirm a ruling blocking Mr. Trump's first travel ban. Judge Orrick is a district court judge whose decisions may be appealed to the Ninth Circuit. Though only 2 counties had challenged the sanctuary cities order, Judge Orrick issued a nationwide injunction temporarily blocking it. Here, too, he took a page from what was until recently a Republican litigation playbook. In cases concerning Mr. Obama's initiatives on immigration and transgender rights, individual judges in Texas concluded that nationwide injunctions blocking them were warranted. Republicans embraced those rulings. Now they are less certain that individual federal judges should be able to wield such power. Once again, a single district judge, this time in San Francisco, has ignored federal immigration law to set a new immigration policy. The entire country, in a statement released Tuesday. Mr. Trump's first travel ban was also put halted by a nationwide injunction entered by a judge in Seattle, and his revised travel ban was blocked by nationwide injunctions from judges in Maryland and Hawaii. That last order did not sit well with Attorney General Jeff Sessions, who criticized Judge Derek K. Watson of Federal District Court in Honolulu minus a judge sitting on an island in the Pacific, as Mr. Sessions put it, minus for issuing a ruling that would apply to the whole nation. But Judge Watson relied on a 2015 appeals court ruling blocking Mr. Obama's immigration program, said such nationwide injunctions were required to ensure uniformity. The appeals court affirmed an injunction issued by a single judge in Brownsville, Texas, who said Mr. Obama had exceeded his authority. As a senator, Mr. Sessions cheered that ruling, saying it was an injunction, stopped the Obama administration from proceeding with its lawless immigration system. Both sides have been flexible in their understanding of the applicable legal principles, Professor Blackman said. With respect to nationwide injunctions, he said, blue state attorney generals are relying on arguments they expressly opposed during the Obama administration. It is time to embrace neutral legal principles, Professor Samin said. Whether they help one side or the other in any given case, that would, he said, help tamp down the dangerous partisan conflict and hatred that are poisoning our political system. Neil S. Siegel, a law professor at Duke, said the Supreme Court and the public should think hard about the recent whiplash-inducing litigation turnabouts. A question we will eventually want to ask the justices is a question we should also be asking ourselves, he said. Who is prepared to be at all principled about these matters?